All right, good morning, everyone. This is JJ Arisha with Pismo Ventures, and I have with me today Stephen Kusama. I have Bruce Itchkawitz from Kenobi Martins, as well with Rabi Narula from Kenobi Martins. Today, they will be discussing key IP agreements for startups. Thank you for being here. I'll give the floor to you in a couple of minutes. I just wanted to give everyone an update on where we're at as far as the competition is concerned. So all the evaluations for round one will be completed today, and we will have an announcement tomorrow for all the startups that made it from round one to round two tomorrow, Friday. So so stay tuned for that. For the ones that make it to round two, the business to business category will be on Monday at noon. So be ready to start with a 5-minute pitch and 5-minute Q&A to the panel. That's, if you have not practiced that, I would spend the weekend practicing that to make sure you get it right, because you will be cut off at 5 minutes when you're done with your pitch, or even if you're in the middle of your pitch. And you'll be also cut off at 5 minutes when for the Q&A portion of the presentation. Best of luck to everybody, and a lot of work. Tens of judges and investors have spent a lot of time on evaluating all the applications. Some of the applications have notes in them, meaning some of the judges have put notes in there, providing some feedback. If you are interested, either regardless if you make it or don't make it, if you're interested in what the notes say, we're happy to send you all the notes that the judges put in there. Some have notes, some don't, so I just want to make sure you understand that part. Other than that, the timeline for the competition and all the events is on ventureplancompetition.com. So please read it there, read the information, because there's a lot of information that includes all events, all deadlines, all timelines. So please read them there. Right after this, just like we've been doing at every webinar, there is a virtual networking time, and the link and the password is now in the chat. So please, you need both. Please copy both the link and the password. You need both in order to get in. It's right after this webinar is done. Well, thank you again. I'm going to give the floor to Mr. Itchkawitz and Mr. Narula. Please take it from here.
Okay, well, thanks, JJ. So, and thank you everybody for joining us. My name's Bruce Itchkawitz. I'm a patent attorney at Kenobi Martins, been practicing for about 20 years, focusing on a client development practice, which includes patent prosecution, as well as work on some agreements, some of which we're going to talk about today. Let me just give my colleague Rabi a chance to introduce himself, and then we'll get started.
Hello, everyone. Yeah, my name is Rabi Narula. I have also been a patent attorney for about over 20 years now at Kenobi Martins. I have a background in mechanical engineering, and I have what people call a client practice focused practice where I focus on working with startup companies, helping them develop their IP strategy, building that up, so hopefully eventually one day it can be acquired and exit. I'm looking forward to the discussion today.
Great. So the topic of the discussion today is key IP agreements for startups. And first, I hope anybody will tell me if I happen to have a fly that lands on my head during the course of this presentation.
Just a quick
property is, I think everybody knows.
Quickly, if anybody wants to ask questions, please ask it in the Q&A section, and then we will get to it. I didn't want to interrupt you. I'm sorry, Bruce, but please ask questions in the Q&A. If it's relevant to the immediate subject, Rabi and Bruce will take it on. If it's not immediately relevant, they will answer it towards the end. And also at the end, we will open it up for audio questioning if someone wants to ask a question via audio. Sorry, Bruce, go ahead.
Yeah, no problem. So I think everybody is aware that intellectual property, IP, is a key source of value for any startup company. The IP can include typically patents, trademarks, copyrights, trade secrets, and each of these types of IP can be used to distinguish the startup from its competitors, to perhaps attract funding from potential investors, or to make the company more attractive as an acquisition target. The IP and the startup's efforts to protect its IP are going to be a focus of due diligence when those types of activities occur, when a venture capital company, for example, or other investors are looking to gauge the value of the startup. They're going to look at what IP you have and what have you done to protect that IP. So there are various agreements that startups have to be aware of during their lifetime that have impact towards protecting their intellectual property. And we're going to talk about some of them, a list here, including non-disclosure agreements, so sometimes they're called confidential disclosure agreements, employment agreements, consulting agreements, assignment agreements, where it's a transfer of ownership, development agreements also have key aspects of IP are relevant there, and license agreements. So overarching throughout all these various agreements, there are basically two key concepts that we're going to be discussing and touching on. They're important for the valuable exclusivity that the IP provides. The first one is confidentiality. Some types of intellectual property, trade secrets, for example, derive their value from the exclusivity from being known only to the startup. The startup, no one outside of the startup knows of this information. And trade secret information, it doesn't have to be technical information. It can be business related. It could be customer lists. It could be pricing calculations, anything that is not known to the outside world. And what you're trying to do in these agreements, when sometimes that type of information has to be disclosed or even used by the startup, you want to ensure that others don't free ride off of the development, your efforts as the startup to produce this confidential information. Also, another key aspect is the ownership. Other types of intellectual property, patents and trademarks and copyrights, for example, they derive their value from being practiced only by the startup. I mean, they're known by other people, but because of the protection you put in place, for example, patents, they cannot practice that intellectual property without your permission. And in terms of ownership, what the key aspect of what these investors look at and what you want to make sure you protect is that you own what you think you own. Sometimes that's not as clear cut as what you might first think. For example, one avenue of quote unquote leakage of ownership is through what's called joint inventor ownership, I should say. Joint owners of IP, for example, a patent, each have the right to practice that intellectual property, and they can license it non-exclusively to others, independently of the other joint owner. So they can, whereas you think that you own something and you're developing, you're negotiating a license with someone to use that IP. If there's a joint owner, that could be an avenue for your potential licensee to get access to that same intellectual property without going through you and without paying you. So that can be a definite problem. joint ownership also has the problem of the fact that if you're ever going to sue someone for infringement of that IP, you have to have that in terms of patents, at least, you have to have all the joint owners join the litigation. And if they don't join, then you can't end up suing the infringer. Again, a problem that you want to avoid. So,
Bruce, I just go
yeah,
back
go ahead.
to that slide. I was just a couple extra points I wanted to emphasize. Confidentiality is also important for preserving your ability to patent your invention. Many countries and require that to file a patent application, there can't be any non-confidential disclosure of the invention. So if you haven't filed your patent application yet, and you're planning to talk to other people about it, at the very minimum, you need to have a confidentiality agreement in place. So that's another reason why that is a key aspect. Another thing, and we'll get into this as there's a lot of different agreements. These are, I think it's important that these agreements are in place at the beginning of your company. And so oftentimes a good corporate attorney that is familiar with startup companies and technical companies will be helping you with some of these agreements, and or your IP attorney that you have in the beginning will be kind of working together to make sure that you have these agreements at the very formation of your company.
Yeah, good points. Thanks, Robbie. Yeah, that's how this presentation is going to go. We're both going to chime in when we have something to say. So let me just touch on what the goals are for today. What we're hoping to cover is how these two primary concepts, confidentiality and ownership, are addressed in these various agreements that startups are going to have to utilize at one point or another. And what we're hoping that you get out of it isn't that you suddenly become a patent attorney. And we're also not trying to give you any legal advice. What we're just trying to do is give you some information that will hopefully help you better communicate and work with your IP attorney to put agreements in place that do the job for your startup. So let's first start talking about non-disclosure agreements. They are focused primarily on the confidentiality aspect of the IP. And as I mentioned, that you may end up needing a non-disclosure agreement when you're trying to raise funds, and that may be while trying to raise funds, you may be sort of eager to disclose your intellectual property, right? You want to give your pitch to investors. But you want to be careful in terms of what information you disclose or not. And if you do disclose something, ideally, you want to have it protected by the non-disclosure agreement. But, actually, a lot of venture capital companies and investors aren't going to sign NDAs. And so we're going to talk about why, what else you might do in lieu of that. It's just part of the realities of the business. They evaluate hundreds of companies a year in terms of who to invest or not, and they don't see the benefit to them to signing hundreds of NDAs and trying to keep track of their obligations in all of them. It might also be that the startup wants to disclose because they're trying to get a collaborative project going with a consultant or some other third party. But there's an inherent problem there too, because while some disclosure may be needed so that the collaboration can be successful, you have to guard against the fact that maybe today's collaborator becomes tomorrow's competitor. You don't want them to be able to free ride off of the information they accessed to you at this early stage to become a competitor against you. So as a startup, you shouldn't lose sight of the goal of protecting your IP, just in the desire to minimize delays or obstacles to either these efforts to raise funds or to get collaborations going. One thing that we'd caution against is using incomplete templates or boilerplates that they don't properly address your situation. We're going to talk a little bit about what the key aspects of a non-disclosure agreement should include. but I also want to mention about, some of the other common sense measures that you could take in addition to NDA, or, in examples where, maybe a VC doesn't want to sign an NDA, what you can do to try to reduce the risk. Well, how, the best way to protect something is to limit disclosure of that information. Limit your disclosure. It's better not to disclose rather than going through the time and expense of litigation, even if you have an NDA in place, right? If you haven't disclosed that key information, nobody can use it for improper purposes. And then for technical information, type of information that might be expected to be included in a patent application, as Rabi alluded, best way to protect that may be to get a patent application on file that includes that before, and you want to do that before you disclose that technical information. And you might think of it as a belt and suspenders, two ways of protecting the information, but why not? That's a good thing to do. Even if you are having an NDA signed, there are reasons that you want to get a patent application on file before you ever disclose.
Just a few comments, Bruce. I just want to emphasize again, I think a key point there, I think probably the biggest mistake I see startup companies doing is using the same or template NDA for all situations. The one NDA, there's no way can cover all situations. There are times where you're going to want it to be stronger or weaker. We're going to talk about that. Even with the same entity, you may have a first NDA for an initial meeting that may have, maybe for lack of a better word, be weaker. But as there's more information planning to be disclosed, more sensitive information, you could imagine having subsequent NDAs. And so that's another way to kind of get things going, is to stage the disclosure of information and stage the type of agreement you might have with the other side.
Yeah. So with regard to these NDAs, to try to avoid those problems and to increase the enforceability of the NDA, is a court actually going to enforce it if you ever do need to litigate? It should be appropriately written for the purpose it's intended to satisfy, as Rabi was explaining. And so it should be explicit in a number of different areas. First one is the purpose. Why is the information being exchanged? The purpose should be defined with specificity, and it should be referred to in the use provision of the NDA, which I'm going to get to in a moment, that clearly expresses the parties' mutual intention regarding how the information is to be used and how it's not to be used. The NDA should also be explicit in terms of what is the confidential information, what information is considered to be confidential by the disclosing party. In some instances, you might want to have it defined broadly because maybe you're not exactly sure of what actual information is going to be disclosed. You could define it as being only written, or it could be written and oral disclosures. You could also define it more narrowly in other instances where you know what specific information is going to be disclosed. For example, specific documents or data sets. Typically, the definition of the confidential information is also going to enumerate some various exceptions that cannot be considered to be confidential information. Like it's typically going to say information that was already publicly known. You can't try to cover that under the ambit of confidential information. The NDA is also going to be hopefully explicit about the obligations on confidentiality and the obligations on use of the confidential information. It should clearly and unambiguously describe what the receiving party can and cannot do regarding the confidential information. What must they do to keep that confidential information secret? How long are their obligations required to be maintained? uh, associated with that are, who are the permitted recipients of the confidential information? With whom can the receiving parties share it? Their affiliate, can they share it with their affiliates or their key personnel? And under what conditions does that sharing have to be maintained? Whoever it's shared with, at a minimum, hopefully, they have the same obligations to keep the information confidential that the receiving party has. Otherwise, that's a potential leak of the information that you want to try to avoid. And then ownership. You typically want to be explicit with regard to parties retaining their respective IP that they've had before the agreement is entered into. That there are no IP licenses being granted, right? This is just the early stage disclosure. And sometimes in these circumstances, you have to address the ownership of any new IP that might arise from the fact that now somebody else is aware of this confidential information. Maybe they end up having some improvements, some potential new inventions that are based on that information, or at least are created by virtue of their exposure to the disclosing party's confidential information. And then the last thing on this slide, I would say, is that there are some other provisions that oftentimes a non-disclosure agreement would have. For example, a clause that's requiring the receiving party to notify the disclosing party when any newly developed IP, as I was referring to, is created based on the disclosed confidential information, and to disclose that newly developed intellectual property to the disclosing party. You want to know if the party that you disclosed your confidential information to is trying to build upon that by creating their newly developed intellectual property, and also whether they should notify you if they've made a decision about whether to develop a product based on their newly developed IP, or as well as your IP. By having that can help limit damages and can help show bad faith when they don't give you that notice, right? If you disclose your confidential information to this the receiving party, and then without them telling you, they go out and make a product that incorporates this confidential information or uses it in some way. Well, if you have this notice provision in your NDA and they haven't provided you with that notice, well, that sort of shows that they went behind your back, and it can help in any litigation that you try to bring in that circumstance.
Just
Robbie, any
yes,
thoughts?
just a couple points. Another term that is often negotiated is how long is information kept confidential. As somebody who's disclosing information, I would try to advocate to have it forever. There'd be no time limit. Whatever confidential information I disclose is kept confidential forever. However, you'll see oftentimes that the other side will argue for a set term, a year, 2 years, 3 years, 5 years. And again, that may be acceptable depending on the context. It's just something you need to know if there is a time limit on the NDA. Is that information that was going to be, publicized in a year or two anyways, and so that's not a big risk for you. Or if it's really important information that you were planning to keep for trade secret forever, having such a time limit would not be acceptable. So that's another thing to watch out for. Is there a time limit on the period of confidentiality? So there are a few, I'm seeing a lot of questions, and maybe Bruce, we could pause this a little bit about asking about early startups and doing kind of the initial pitches and talking to potential investors, and whether or not you need to have an NDA in place, and whether or not that could, potentially be a problem if you're disclosing sensitive information in a pitch slide without having a NDA in place.
Sure. Yeah, I realized I didn't have the chat up, so I wasn't seeing that. While I try to find it, maybe you can.
Yeah, and so, yeah, so I mean, the preference is to have an NDA in place before you disclose any confidential information. So sometimes that's not possible. And if that's not possible, but you want to have at least an initial discussion, is you would keep the slides and any information you disclose at a very high level. So an example, so certainly if you're saying, I'm trying to solve this problem and there's other companies that are also trying to solve this problem, and you're describing the market and the opportunity, that maybe is not as sensitive information, and maybe you're comfortable disclosing that without an NDA. But maybe actually giving into your solutions, your technical solutions of the problem, would be something that is confident, you want to keep as confidential, and you would not be comfortable disclosing to the third parties without an NDA. And maybe you would wait for a second round, a more detailed discussion later, and insist upon an NDA being in place at that time. So that might be a compromise you could make, to stage the information, keep any pitch slides at a very high level that you're comfortable showing to anybody without an NDA in place. Is there anything you want to add to that, Bruce?
No, I think that was good. Let's see. So then let's see, I've seen that the second question was, to what extent does a broad generalized description of, proprietary technology in a VC presentation constitute disclosure that might impair future patentability? Well, the broad type of description that you might include in a pitch hopefully isn't the type of nitty-gritty information specifics that someone could then use to, for example, if it's technical information, to make and use, the invention. You can talk about, what its overall goals are, and touch on maybe in general the category of the type of solution that you're bringing to bear. But you wouldn't want to go into anything that is so specific that someone could then run with it and use it to make and use the invention. And then anything to add on that, Rabi?
No, I think I can move on.
And then the last one is, can you provide by email to all attendees copies of various NDAs and CDA templates? Well, part of what we're trying to caution you against is just using templates. But there are templates on the web if you wanted to go out and search. We don't have any that we would disseminate in public, throw out there, but it is something that, when we work on something, we like to know the details and make sure that the NDAs that we work on are address all the points that we're talking about today. So let's see, did we answer all the questions there?
I think so. Unless Pismo, do you think we missed something?
Yeah. I see one. Is the existence itself of an NDA between two parties considered confidential if not explicitly specified in the agreement? Well, no. Typically, if you want the existence of the agreement to be confidential, you want to put that in explicitly in that agreement, just so there's no question. There isn't any default that it's confidential unless determined otherwise. So you want to say that explicitly in the agreement. There was another question about with regard to the cost of the patent process and what a startup can do to attract investors without a patent. I think that's a little off topic for the moment. We can loop back with that at the end if we'd like. So unless you have any other comments, Rabi, we can go on to the next slide.
Sure.
Okay. So the other thing about NDAs is that we just want to caution that you yourself should be judicious about what NDAs you're signing or not, because they're putting obligations on you to keep the confidential information of others secret. And you want to, if you're signing such an agreement, you want to be sure that you know what your obligations are and how long you have those obligations, and so on. So I'd also like to just sort of touch on an example of where an NDA became important to a company. And this is a case of Oculus, which you may have heard of. They develop virtual reality systems. They had entered into an NDA with another small company at the time in order to collaborate on developing their Oculus Rift virtual reality headset. At the time, there was a guy who was working for ZeniMax who wrote 2 video games that Oculus ended up using in their demonstrations and to show to potential investors. This guy eventually ended up being hired by Oculus as their CTO. But before he left ZeniMax, he copied thousands of emails and source code that he later used while he was at Oculus. Well, ZeniMax sued Oculus, who by then had been acquired by Facebook for $2 billion. So that ZeniMax sued Facebook and a bunch of the officers for various counts of trade secret misappropriation, copyright infringement, trademark infringement, and breach of contract, i.e. the NDA that was signed way back when. In February of 2017, a Texas federal court found that Oculus and its executives were guilty of some of these accusations, including breach of the NDA that Oculus had signed way back when. And the jury in that case awarded damages of $500 million to ZeniMax, and $200 million of which of that was just for the breach of the NDA. Subsequent to that, the parties reached a settlement. We don't know what the terms are of that settlement. It was secret. But this example shows that an NDA, which really wasn't anything special, it had standard provisions in it. But what it did, it set out the proper terms for such an NDA, and it set the stage for being held valid by this federal court years down the line, and supporting a multi-million-dollar judgment. So it behooves a startup to try to get things done correctly at that early stage.
And there's a general trend of increased trade secret litigation in the United States. It's been increasing every year. Part of that's, I think, the ability for people to take trade secrets faster nowadays and in today's times than it was maybe 20 years ago. And also some expansion of the federal jurisdiction to be able to adjudicate trade secret litigation.
Yeah. So let's transition from NDAs now to employment agreements. And so I'm going to hand the talking stick over to Rabi.
Yeah, no worries. So an employment agreement, again, we talked about how at the very beginning of a startup, there's certain agreements you should have in place. And so I think it's best practices that if you have a company and you have an employees, all the employees should have an agreement with the company in which they assign all inventions, copyrights, intellectual property, trade secrets to the company. And that agreement should use very specific language. It's there on the slide there. An employee hereby assigns. The key thing is hereby assigns. It's a present tense. It's not a promise to assign. It's an actual assignment. And so you want to make sure that's in the agreement. Again, for everybody from day one of employment, this is something they should be signing. You don't wait till 6 months in or a year in. You want to do it from day one. And that's because in many countries, and in particular the United States, the assumption is that the inventor is the owner of an assignment. There are some countries like Switzerland that have different rules that are more pro-employer. In the United States, I think to be safe, you want the assignment from day one. The other issue that people come up with is, what do you own? And usually you want to make sure that there's a provision there that is inclusive as possible without violating state law. So in general, I think the employee would be obligated to assign any IP that they create that relates to the company's business, R&D using any R&D using the company's equipment, or confidential information. And that kind of dovetails with the California state law, which says that if you go beyond that, basically if an employee makes something on their own time without using company equipment or without confidential information, the California law says that's something that the employee should be able to own by themselves, and that the employer cannot own through an employment agreement. And so you're basically trying to make own everything up until the extent of the law. And it kind of makes common sense if you're working for a company that makes the software and in your garage on your own time, you make a better mousetrap without any confidential information from your employer. That should be something that you should be able to own by yourself without having an obligation to your employer. But again, from the company's point of view, you want to make it as broad as possible without violating the state laws. And each state's a little different, so you should look at where your employees live and work, and make sure you're in compliance with state law. And again, if they work outside the United States, each country may have their own provisions also. Another thing you want to make sure is that you have the employee list any prior inventions, if they're an inventor on something else that's been filed from their prior company or on their own. And also that they confirm that they're not under any other ownership obligations, that they don't have a side job or another employment where they maybe have an obligation of assignment to another entity. You also typically want to make sure there's some obligation that they don't use confidential information from some third party or prior employer when they're working with you.
Right. Yeah, and though that can be important down the road if you're ever sued for using the confidential information of that third party. You can point to the employment agreement and say, look, we had our employee, he or she was on notice, knew they weren't supposed to do that. We weren't aware of it, and so on. The other thing I would just point out to that, where that can often come to bear, is when the employee is maybe a former university researcher, where maybe the reason they were employed was to build upon that research that they were doing, but they may have already be obligated to assign their ownership of any such material to the university. And now that, so you don't own what you think you own, because that some of their work is actually owned by the university. So you want to make sure that the employee acknowledges that no, they're not under any obligations of ownership to third parties such as universities.
Can I go to the next? We're going to hit the first two bullet points here. I want to get to the third bullet point, Bruce.
Okay. Yeah.
Yeah. So we talked about, again, don't use third-party confidential information. Another key thing about an employment agreement is that there's a procedure to have exit interviews when employees do leave. And what you want to do in that exit interview is there's probably a document that they're going to sign that reminds them about their obligations regarding ownership and confidentiality. You maybe have them list out any current inventions they're working on. You might at that time take the steps of getting assignment documents, which we'll talk about later. You also may have them, sometimes I've seen companies ask that if the employee files for a patent application within 1 year of ceasing employment, that they at least provide notice to the former employer about the contents of the patent application. So these are all things you might want to do on the exit when somebody's leaving to make sure that, again, they're not taking anything away from you. There may be obligations about returning any kind of laptops or information on laptops and certifying that they destroyed that type of any confidential information and or other provisions you might see.
Right.
All right.
I don't have anything to add to that. So I'm going to go on to the next slide.
So returning from an employment agreement, there's also assignment agreements, and we'll talk about an inventor assignment agreement. So once you file a patent application, you often ask for the inventor to sign another document, which is an inventor assignment agreement. If you've done your things right and you have an employment agreement in place with a strong assignment provision, and/or we'll talk about consulting agreements later, in theory, legally, they have already assigned the invention to the company. But as attorneys and as a company, I think you want to be extra safe. And I think the best practice is every time you file a patent application, you give an explicit assignment of that patent application to the company. And that's a standard, this form, this is more of a standard form, and there's less kind of changes in that standard form as compared to other agreements. But it's very important that the agreement define the invention application properly. Usually that involves specifically identifying the application number and filing date and title of the invention. You can want to use the present language of hereby assigns. There's case law on that says that that should be in the agreement or must be in the agreement to be effective. You want to include all future related applications or improvements and the right to sue for past damages. And this same form of an inventor assignment agreement would be similar if you were actually getting an assignment of a patent from a third party. You would want to have similar types of language in the patent agreement also. And a few things, it's very important to do these properly. I've seen a lot of startups get in trouble because they forget to do this. And so it is much easier to have an employee sign this agreement while they're working for you than when they've left. And so, so that's why in the exit interview, it's a good time to check to say, hey, do we have any outstanding inventor assignments? That's a good time to have them sign it at that time before they leave, because just from experience, it's hard to track people down when they've left your company. And when you get into foreign prosecution, it's very important to have these assignment agreements in place. Do you want to add to that, Bruce?
Yeah, I guess only to address the question that just popped up, that asking, well, for how many years is the employee assignment to the company hold good? Well, it's an assignment, it's ownership. You're you're basically selling it. Whoever you assign it to owns it for now and forever until they assign it to somebody else. So there's not a time limit on the ownership. That's the type of term that you might be thinking about is more in line with what would happen in a license agreement. And we're going to touch on that a little later in the presentation.
I think the other point they may be saying is for an employment agreement, when you have an obligation to assign to the company and then you're terminated, how long after termination can the employee or employer still claim that they own the inventor's agreements? Again, there's state law provisions on this. I think the way that I would look at it is if you're taking confidential information from the company and improving upon that confidential information, there might be a pretty long tail on that. It's going to depend on the state law and the facts. But in most states, it's going to be unconscionable and not enforceable to own what an employee makes, after they leave the company, if it has no tie to any confidential information. You can't, that would be, you can't tie somebody up for years and years or even, months after they leave a company and own everything they make if it's not tied to confidential information that they get at their employment.
Yeah. So that brings us to consulting agreements, which are, in some ways similar to employment agreements. They have the ownership and the confidentiality provisions that employment agreements have typically, but you have to be even more careful because consultants are not employees. You may have heard the term work for hire, and you might say, well, wait, I've hired this consultant to develop some IP for me. And so you assume that the company automatically owns anything that the consultant developed with the company's funding. But actually, for most forms of IP, like patents, the opposite is true. There is no automatic transfer of ownership just because you paid for the development of the IP. With patents, as well as other forms of IP, it's the original author or inventor that's presumed to own the IP rights that they developed, even when the company is funding the work. And so, as we've said a number of times here, to make sure that the company owns what they think they own, you have to get a written assignment. In this case, a written assignment within the consulting agreement or afterwards. So with regard to work for hire, I mean, that it is a phrase that is used with regard to copyrights, but it's very limited, and even there, it's not necessarily automatic. A work made for hire under the federal statutes is a work prepared by an employee within the scope of his or her employment. It doesn't matter whether this person is called an employee or not, what the title is. It depends on the degree of control that the company has over the work as to whether they're going to be determined to be an employee under the statute or not. For example, how or where or what equipment is being used to do the work. What control does the company have over the employee's schedule? What is the status and conduct of the company with regard to the work? Do they withhold, and the employee? Do they withhold taxes from the employee? Do they provide benefits to the person making them an employee? So that's one aspect of, okay, if you're an employee, you could be under the work made for hire for copyrights. There's also another aspect of if it's a work that is specially ordered or commissioned for use as one of an enumerated set, like an atlas, a translation, a collective work. But even there, the parties have to expressly agree in writing that yes, what the consultant is providing is a work made for hire. And this enumerated list of particular importance doesn't include software. So while software can be included as a work made for hire by an employee, it doesn't necessarily qualify as a work made for hire by a consultant. So you can't just rely on the parties agreeing that the work is made for hire. They can't. That's not a magic phrase. What you do need to do is make sure that you get the assignment in writing, because one thing you don't want to do is be subject to a court deciding whether your author is an employee or an independent contractor or not. That can be a real morass in a litigation, whereas it's just so easy just to get the assignment up front in writing. Anything to add, Rabi?
Yeah, I think consulting agreements is a place where some due diligence is also important. Like, who is your consultant? Where is he working? What's his daytime job? If he has one. Is he working for a university? Even though you may have a very strong consulting agreement, the person who is consulting with you may have superseding obligations to another entity. And I've seen in situations where those two things clash, and that results in uncertainty, litigation, and that's what you're trying to avoid with these agreements. So, so I've seen in situations, for example, with a university where you might even have the university confirm that this consultant, they're aware of the consulting agreement and the assignment and provisions of the agreement, so that they're on board with the fact that their employee is doing this consulting and maybe assigning their IP to a different party. So just something to keep in mind when you're hiring on a consultant.
Yeah. So Rabi, why don't you continue on and start talking about the development agreement?
Yeah. So development agreements, as that first bullet point says, they're more complicated. Those other agreements there that we've talked about, you might have a standard or a template that you start with. And there exists some development agreement templates out there, but from my experience, these are going to be more expensive and more customized agreements. That's just the very nature of them. And this is because a development agreement, you're talking about a relationship between two parties where you're going to develop a product, and you're usually coming into that relationship with pre-existing IP or intellectual property that you each individually own, and then you're going to be working together, sharing costs, maybe funds and testing, and jointly developing IP in the future. And that just creates complications. For example, one of the basic complications is who's going to own the newly invented IP. And you're going to want to be very clear about that up front, because in general, if the inventors are from both parties, the inventions are going to be jointly owned. And that's usually not a good place to be. Jointly owned means both sides have to coordinate with each other on all enforcement actions, license actions, and stuff like that. So really nobody owns it in those situations. So it's very clear to have these upfront kind of think through, okay, we're going to try to make a product, we're going to try to do something. Who's going to own that IP? And you want to put it into buckets. For example, you can imagine that each party clarifies that they own the IP they bring into it. Maybe newly developed IP is owned by one party, but there's an exclusive license to certain fields. There's hundreds of different ways you can divide up the IP. Each situation is going to be different. What I want people to do is just go in there and make sure you've thought it through and that both sides understand who owns the IP as the result of this joint development agreement.
Yeah. So the one thing I would just add is this very last bullet point, and it touches on something that we had talked about before, but you can include a notice provision that, if either party does develop some IP, that they have to disclose that fact to the other parties, just to avoid one of the parties trying to be secretive in terms of using the IP that's developed under the development agreement without sharing it. Again, a notice provision can help show bad faith if they ever try to do that.
Right. Other provisions might be, who controls prosecution of any jointly owned IP, that is, who controls the patent filing process, who pays for it, where do you file foreign. There might be milestones in part of the joint development agreement in terms of and ways to get out of it. So it's a much more complicated agreement. And I think you definitely need to have an IP attorney involved with drafting this up.
Yeah.
So the final agreement we wanted to talk about was a patent license agreement. Again, these tend to be more complicated agreement on average. And so I would, again, strongly would have an IP attorney reviewing these types of agreements. A couple concepts we wanted to kind of emphasize about patent license agreements are that this grant or the scope of the license agreement can vary in a lot of different ways. For example, a license agreement can be exclusive. That is, you are the only person that gets to practice the patent. Even the owner can't practice the patent in some agreements. That's an exclusive license. Or you can have a non-exclusive license where the patent owner gives you the right to use the patent, but also will give it to other people too. And so this idea of a range of what can be granted to you, exclusive versus non-exclusive licenses. In addition, there can be limitations based on things such as geography or field of use. So it's not, you may see some license agreement out there that say you have a license to use this technology only in the United States. Maybe some other entity has it in Europe. You can also imagine field of use licenses where you get to use it in the patent in a certain industry, and other people can use the patent in another industry. So these are all terms that can be negotiated, and you can really divide up the rights of a patent in a lot of different ways with a license agreement.
Yeah, and it's important that it's an important distinction of a license agreement from an assignment, because the patent ownership, using patents as an example, cannot be divided by field of use. It already does. A patent inherently has a geographic limitation on it in terms of the country that issued the patent, but the ownership can't be divided in terms of some sub area of the country, and it can't be divided claim by claim of the patent. But you can do all of that using a license.
A license agreement often has a payment term, and again, this can vary in a lot of different ways. It can be calculated by a percent of royalty revenue, or a royalty based on a percent of revenue. It could be by unit. It could be a flat fee. It could be a upfront payment. It could be based on milestones. It can vary based on the year or the volume. So there's a lot of different ways you can work out the payments or royalties associated with a license agreement.
Yeah.
Another term. Yeah, go ahead.
Yeah, I was just going to mention, some of the milestones that you might have that are worth changing, bump up of the royalty, or some other change of what the payment might be based on those milestones. Is once a patent issues, right? Okay, well now you have some exclusivity, so maybe they should pay more for now that the patent is issued, or maybe you've achieved FDA approval of the underlying technology, or maybe there's been you've reached a certain amount of sales. All those can be types of those milestones that Rabi was alluding to.
And then transferability and sublicenses, or the ability to grant sublicenses, if you have the license to the patent, are very important. That is, if you're being acquired, one of the things an acquirer is going to look at is, okay, you have this great license from a company. Is it transferable? That is, if you get acquired, does the license go with the new company? And that might be something that is not in the agreement, but as the person who's getting the patent to license, you would want that in there. Also, the ability to sublicense, if you want to have a subcontractor make certain portions of the product, that might be an important term for you. That's another term to look at when you're looking at a patent license agreement. IP management is another one, like, again, who's paying for the IP and the patent, who controls prosecution, who pays maintenance fees. People have talked about how it can be very expensive to file outside the United States. So that's something that could also be addressed in a patent license agreement. And finally, there's usually some types of representations and warranties. For the licensor, the patent owner, they're usually repping and warranting that they own the patent. They have a right to grant the license. They may disclaim that they have any kind of idea that the invention works or that it doesn't infringe anything. And then even by the licensee, they might have some terms that disclaim any implied warranties that is given by the licensor. So these are reps and warranties at the end, potentially some indemnification terms also. These are all important terms that you want to pay attention to and have your attorney review carefully.
Yeah. So yeah, license agreements could be its own topic for an hour or more discussion. And maybe we'll do that at a later time. It's a very rich area. So I just, I think that brings us to the conclusion of the presentation, the information we wanted to provide. On this last slide is our contact information for me and Rabi. We invite you after the fact, if you want to contact either of us with some other questions. I see we have a couple others in the Q&A we'll get to in a moment. But feel free to contact us, and we'll see if we're able to answer your specific question. Let's see. Let's go through the questions that are in the Q&A. First, the one that we had put off from the beginning was, since the entire patent process is very expensive, which it is, and sometimes provisional patents are really not worth it. I disagree with that. If they're done right, they are very worth it. If they're done slapdash, no, they're not worth it. But what can a startup do to attract investors without a patent? Well, sometimes investors are looking for that exclusivity, and if it's information that technical information that has to be either disclosed just as part of the nature of the information. For example, if someone tried to reverse engineer your product, they would be able to find out this information. You need a patent to protect it. There is no way to otherwise. But if it is some information that you can keep confidential, maybe it's a method of manufacturing of your product, well, then you have to do what you can to keep it secret. You're basically trying to protect it via trade secret. And the key part of that is keeping it secret, having measures in place that the information is under lock and key effectively, that you limit the number of people who have access to it, and so on. So that's the type of things that you would have to go through to protect that type of information. Rabi, do you want to take the next question?
Yeah, so next question was, if a patent is assigned to a company, then the patent will expire in 17 years, and the employee can freely use it after 17 years, question mark. So a couple of things about that question. First of all, it doesn't expire in 17 years. It's actually, the general rule is that it's 20 years from date of earliest priority a patent application expires. And that can be, there's a little wiggle room on that depending on some delays at the patent office, but the general rule is about 20 years from the earliest non-provisional application that was filed. But yeah, in general, that's the way patents work. Once the patent expires, naturally, it is then in the public domain, and anybody is free to use what's taught in the application, in the patent. Now, the key thing there for a former employee is confidential information. Trade secrets can last forever. So you can practice what's disclosed in the patent application, but if there was some underlying trade secret that is still kept a secret, there might be some, even after 20 years, theoretically, there could still be some trade secret obligations or confidentiality there. But with respect to the patent, after it expires, it's open to the public.
And let's see, I'll take, Mohan asked two questions, one of which I can answer, one of which I can't. But the first one I can't, I mean, why is Qualcomm's patent license agreement litigated in courts? I don't know the specifics of what license agreement you're referring to, but in general, yeah, these license agreements can well end up being litigated because for example, the licensee wants to get out from under, or the licensor thinks that the licensee has violated the terms of the agreement. Well, they aren't self-policing. In order to get damages, you have to bring the other party to court. That's the US system. The second question, any example of companies not filing a patent to keep their information secret or confidential? Sure, there are a lot of them. The classic example is Coca-Cola having a trade secret in their recipe for Coke. And they don't have a patent on that. They keep it under lock and key. They keep it secret. And as Rabi alluded to, one of the aspects of that is by the virtue of the patent having a limited time that it's good, that's enforceable, whereas trade secrets do not have such a time limit. Coke can keep their the value of that confidentiality in perpetuity. As long as they keep it secret, and they're the only ones that know how to use it, they can gain the benefit of that confidentiality. So let's see, a couple other questions. Well, one is just a statement. Rabi, maybe you can take the next question.
Yeah, what do you think of the what do you think of the prospects of changing the natural 101 stupid ruling? I think that probably goes beyond the scope of this project, this discussion here. I mean, just to educate people, 101 is a statute that defines what can be patented. And there's case law that defines that certain things are patentable and can get a patent on it, and some things are not. For example, laws of nature are things that you can't get a patent on. And so there's been a lot of talk about that because it sometimes bleeds into software or business methods. In the biotech industry, there's often some discussion about what can be patented with respect to genes, very complex area of law, and it's changing and has changed in the last 10 years and could change in the future based on maybe a change in the statute. But that could be a course at a law school on 101. So.
Mm-hmm. Yeah. Let's see. Stephen asked the question, are there any benchmarks regarding what a reasonable license fee would be on either a per transaction basis or lump sum fee? There are general guide marks in terms of, all those types of things, in different technology areas, software versus, medical devices and so on. But in the end, it's going to be something that is negotiated between the parties, and it could be, the focus of a lot of negotiation. So it doesn't really, it's not worth talking about, okay, whatever general benchmarks there might be or not, because every agreement is going to be different. And also these agreements are often secret, so you don't even know what two parties might have agreed to in terms of the eventual license. So there's, Rabi, why don't you take the next?
Yeah, so when a patent owner generates a license for field of use and then subsequently assigns the patent to a new entity, what issues could this create for the three parties, licensee, assigner, and assignee? So we talked about in the license agreement, there's going to be a provision in there that talks about transferability of the license. So usually a patent owner would insist that they could, transfer the ownership, and the license would still be in effect. And that's something that the licensor or licensee would want to have in place. And there may be provisions in there about notice maybe, but these are things that can all be negotiated. That is, in general, people grant a patent license, and then the new owner buys the patent. They would be, there would be provisions in the agreement that says that they would have to be obligated to the terms of the license agreement. That's a typical term to have in the license agreement. But these are things you want to be very explicit about in the license agreement, so that any new owner will be obligated by the terms, or if you don't want it to be transferable, you specifically say that in the agreement.
Right. And then let's see, the last question that we'll get to today. And again, if there are other questions after the fact, please, you can reach out to Rabi or myself. Can a company apply a trade secret to a patent already issued, is the question. Well, that gets into another important distinction between patents and trade secrets. Patents, all the information in a patent becomes publicly known. A patent is published and is publicly available. And trade secrets, by their nature, as I alluded to before, are kept secret. And so there's a dichotomy there. A patent is publicly known, while a trade secret is secret. So I'm not sure what the questioner meant by applying a trade secret to a patent that's already issued. But I'm going to assume that you meant, well, maybe there is some trade secret in some of the aspects of what the patent is, the invention that the patent is assumed to cover. Well, a patent has to provide enough information so that someone who's reading the patent can make and use the invention. So that while there might be some trade secret aspect to it, it can't be you can't hide the ball in terms of how to make and use the invention in a patent. So that brings us to the end of the questions. Again, both Rabi and I want to thank everybody. And JJ, any last words?
Thank you so much for, that was a lot of information. Again, like every time, I keep learning. So that was really, really great. Thank you so much, Rabi. Thank you, Bruce. If you have any more questions, anyone wants to ask a questions via audio, raise your hand, and then we'll be able to bring you in. We'll give you another minute or so to do that. Otherwise, please make a note of the social networking or the networking link in the chat along with the password, and we're going to jump on that right after this. Anyone, is there still any question? There's one more question. What time will tomorrow? That's for me. So we will announce sometime tomorrow. I'm hoping before noon. So if we're able to tally all the data in time. So, but I think we'll try to do it before noon tomorrow. We're going to start tallying the data this afternoon. Stephen and I have a lot of work to do. So All right. It seems like no questions, so we're gonna jump to Ohio Networking Lounge. We'll see you there in a bit. Make sure you copy the stuff before we end the webinar right now. Again, Bruce and Robbie, thank you so much.
Thank you, everybody.
All right.
Thanks.